Bro, look here, bro.
What's that?
It says here that I am fired.
Huh?
It was sent from our boss.
Why so sudden?
I'm so confused. What should I do, man?
I think you can file a case.
File a report. But where?
At the court, maybe?
What kind of court? I think we should look into this together.
Yes, I agree.
Assalamualaikum warahmatullahi wabarakatuh and very good evening to everyone. My name is Muhammad for Female Resmi. Today, I will be the moderator of this forum. So today, I will be guiding this discussion on the topic of the industrial court system in Malaysia. As many of you may know, the industrial court in Malaysia plays a crucial role in resolving disputes between employers and employees in the industrial sector. This forum provides an opportunity for us to discuss and share our knowledge, experiences, and insights on this topic. I encourage you to participate in this forum and share your thoughts and perspectives on the industrial court system in Malaysia. Let's start by discussing some of the key issues related to the industrial court system in Malaysia, including its structure, jurisdiction, and effectiveness in resolving disputes. And let's begin the discussion with introducing our panelists for today's forum. Okay, so for the first panel, Miss Fazli Shafiqah. She graduated from UKM with bachelor degree in Sharia and Law. She is a lecturer in USIM now, and she has experience in teaching for almost 8 years. Okay, so for our second panel, Miss Amni. Miss Amni graduated from USIM in Sharia and Law. She have her own legal firm, and she has experience in this legal field for almost 10 years. So for our final panel, Mr. Shafiq. Mr. Shafiq is a USIM graduate in Sharia and Law. He is also a legal advisor at Bumi Putra Corporation for 2 years now. Okay, so for our first panel, my question for today is, can you describe the structure and jurisdiction of the industrial court in Malaysia and how it differs from other courts in the country?
Thank you for your question. Assalamualaikum warahmatullahi wabarakatuh. The structure of industrial court, it is a tribunal departmental public body with statutory powers. It was originally set up in 1990 to provide arbitration in the industrial dispute, and it still carries out this voluntary arbitration role. Determinations are made by panels of 3 court members appointed by the presidents of court or the deputy chairman, 1 member whose experience is as a representative of employers and workers. The court is supported by a secretariat. The president of the court appointed by Yang di-Pertuan Agong and must legally qualify at least 7 years standing in professional practices. 6 members experience as a representative of employers and workers, and all members must appointed by the Department for Employment and Learning after consulting the Labour Relation Agency. The jurisdiction of industrial court to settle and hear complaints of unfair labour practices under Section 8 of Industrial Relation Act, representation for alleged unjust dismissal of workmen under Section 20 of Industrial Relation Act, reference of trade disputes to the Industrial Court under Section 26 of Industrial Relation Act. The Industrial Court can vary the term of an award or collective agreement to remove ambiguity and uncertainty under Section 23, Clause 2 of Industrial Relation Act. Non-compliance with the award or collective agreement, reference to High Court on question of law, claim for wages under collective agreement. The question of how it differs from other courts for this country, for example, the Labour Court, the differences between Labour Court and Industrial Court, the function of Labour Court, the jurisdiction of the Labour Department of Malaysia under Section 69 of Employment Act 1955, while Industrial Court, the function has jurisdiction to decide an employment dispute in accordance of the Industrial Relations Act 1967 with orders of reference from Minister of Human Resources. Conditions of Labour Court: employees with wages over 2,000 ringgit Malaysia but not exceeding 5,000 ringgit Malaysia, while Industrial Court does not have limitation for the wages, and in Labour Court, the case must fail within 60 days from the date of the decision, while Industrial Court have around 6 years to claim in the Industrial Court. That's all for me. Thank you.
Thank you, Ms. Masni, for your input. Okay, next, for second question, Ms. Amni, can you provide examples of some of the most common types of disputes that are brought before the Industrial Court in Malaysia and how they are typically resolved?
Thank you, Mr. Moderator. Assalamualaikum warahmatullahi wabarakatuh. So for the question, actually there are a lot of common types of dispute in the Industrial Court. Among them is a case of unfair dismissal toward workers in a company, enterprise or industrial dispute between employers or companies, persecution cases related to the workers or the trade union activities, and etc. And the most common dispute that has been brought to the Industrial Court is a workers' dismissal that has been claimed as injustice or unfair. Usually, this happens a lot when the company is having financial problem, such as when the MCO happened like 2 years ago. So the company, they have to reduce the amount of staff they have so that they can balance their finance and the salary for the workers. So for the second question about how they are typically resolved, so for those who are not satisfied or claim that their dismissal is injustice with the company or the employers, they can report the injusticeness that happened to the Industrial Relations Department (IRD). But they have to be made within 60 days from the date of their dismissal. So after they refer to the IRD, they will have a session or process that is called as conciliation between the workers and the employers. So for the result from the conciliation, it's either they have a settlement or no settlement. So if there's no settlement, the case will be brought or referred to the Industrial Court for proceedings. When the proceeding happen, there will be hearing of the case. But before hearing of the case, there are a list of necessary documents to be filed by the either employers or the workers, such as the statement case, statement in reply, rejoinder, bundle of documents, witness statements, and etc. Once all of the necessary steps are done before the hearing, the registrar for the court shall serve a notice by way of Form G, that is a notice of hearing. So upon hearing of the case, the hearing proceeding operate in a similar manner to an actual trial where both the parties call witnesses and present the case. For further filing of document during the trial, one may consult a legal practitioner for advice. So for the final decision, in the Industrial Court, they use the term awards. So award in this context refers to the decision of the preceding case by the Industrial Court judge having listened to the witnesses and parties' submission. So if the court rules in favor of the employee, the employer or the company is obliged to comply with the court order about the employee's statement in the company or payment of a set amount of monetary damages. But however, if the company or the employer disobey by the court's order, if the court find that they are guilty, they can sentence them to pay a fine or serve time in jail. That's all for me. Thank you.
Okay, thank you, Ms. Amni, for your answers. I hope that we know a little bit more about types of dispute that are brought before the industrial court in Malaysia and how they are typically resolved. So for my last question for the third panel, in your experience, Mr. Shafiq, how effective is the industrial court system in Malaysia in protecting the rights of workers and resolving disputes between employers and employees?
Thank you, Mr. Moderator. Based on my experience, the industrial court in Malaysia is very effective in protecting the rights of workers and resolving the dispute between employers and employees. As the evidence, I would like to give a case that was successfully resolved in the industrial court. For example, in the case of On Inso and NG Corporations in Jalan Berhad, the claimant, which is Miss On Inso, commenced employment with company to the positions of senior procurement engineer. The claimant contends that she was dismissed without just cause and excuse by the company on 3rd September 2009. In replying to the comments contentions, the company contends that the claimant was dismissed for gross insubordinations to prove that the claimant's last drawn monthly salary was 5,653 ringgit. After going through and having considerations of the fact of this case, the court opinion that dismissal of the claimant just an excuse based on the section 30 clause 5 of the Industrial Relations Act 1967. Accordingly, the claimant case is hereby dismissed. Therefore, I strongly believe that the industrial court in Malaysia give the best protections to the employers' rights and resolving the problem between workers and employer. That's all from me. Thank you.
Okay, thank you, Mr. Shafiq. So, based on the answers provided to these three questions, it appears that the industrial court in Malaysia plays an important role in resolving disputes between employers and employees. The court system is structurally different from other court systems in Malaysia, and it has jurisdiction to handle industrial disputes. The court seems to be effective in protecting the rights of workers and resolving disputes. However, from the answers provided, it seems that some of the common challenges faced by industrial courts in Malaysia, including ensuring fair and impartial resolution of disputes. It's important to note that this is a broad perspective, and the effectiveness and challenges of the court system may vary in different cases and industries. Overall, the industrial court in Malaysia serves as a crucial mechanism for resolving disputes and protecting the rights of workers in this country, industrial sector. So I think that's all for our forum today. Thank you to the panels for giving me your time for today forums. I think that's all for today. Thank you.